Yes, law school made easy. We are here for contract law, and we're going to break down contract law, and in 10 minutes we should be starting. And in 10 minutes we should be starting. We are going to break down contract law. Of course, the moment you join, send us the topic. Just put in the live chat. Remember to like this chat. Just put your topics you feel you want us to break. But I'm going to handle contract law from offer. Of course, the first thing is freedom of a contract, and then we shall go to offer. We are going to briefly discuss about acceptance. We shall do consideration. We shall put much time on consideration. Then we shall do capacity to contract, and then we shall do the intention to create legal bounds. Invitation to treat two. Of course, when we discuss offer, Mr. Holly, Madam or Mr. Holly, thank you. Invitation to treat, yes, of course, we shall discuss it. Then intention to create legal bounds, and then I'll pick up a few things in content of the contract. We shall do the contra proferentem rule. Of course, we shall do the exclusion clauses, the exceptions of the exclusion clauses. We shall look at the strange case, but of course we shall go within the confines where you have covered. Of course, that's why I'm asking you, those who are on, especially those who are studying right now, you just let us know what you have studied, and then we shall definitely start to discuss, because if I discuss, I may complete the whole syllabus, but when you guide us on what you have covered, it becomes easy. It becomes really easy for me to know. Yeah, so we await. We come early just for people to begin organizing, but in 7 minutes we shall kickstart with the offer. At least offer has been taught in all the universities. But when you come, kindly note, just put up what you want us to discuss. Yeah, what you want us to discuss, and we shall definitely do that. In 6 minutes we should be able to start this live. In 6 minutes we shall be able. Holly, is the sound clear? Those who have joined, you can hear the sound. Somebody type that the sound is clear. I want to be sure. Yes, sir. Okay, thank you. The sound is clear. So we're gonna start in just 6 minutes, such that we begin to break this contract law. Of course, I'm going to try to summarize it for you guys, and at the end of this, one should be able to remind me to try to organize for you how it normally comes in exams. I also tackle that bit. Then every day we are coming up with another session, which will be every day for just 30 minutes on the other channel, Voices of the Bar. So if you have not subscribed, subscribe to the other channel and put a notification. because now on that channel, every day starting on Monday, every day at 10 sharp to 10:30, just 30 minutes. At that is 10 in the night, I will be, at law school, you are not supposed to sleep minus either understanding a concept or reading something new. So I will come with a concept every day. At least by the time you go to sleep, you have grasped a new concept. So every day on the other channel, Voices of the Bar, every day on Voices of the Bar, we shall be having a live broadcast at 10 up to 10:30. It doesn't matter whether you attend or you don't attend. Just wake up every day and look it out. If you missed it at night, go and check it on YouTube. The other channel, Voices of the Bar, check it and watch. We shall discuss a concept. For that one, I won't even be waiting for people. I just come here, I discuss a concept. If somebody comes early, if someone comes early and they give us what they want to discuss, but it will be done in 30 minutes. In 30 minutes every day. And we shall be picking constitutional, history, contracts, foundations of law, criminal law. But every day I will come with a concept. Don't sleep minus appreciating concept. So those who are joining us, just go in your comment section and you put the topics you want us to dwell on, where you think there are challenges. It will be easy for me to start when you have put those nani in there. So just put up your comment that, like Holly has said, we do invitation to treat, which definitely I'll start with when we begin. I'll start with invitation to treat when we begin, and then we discuss that case of Great British Pharmaceuticals, and also we discuss that case of Fisher versus Bell. I try to show you where the invitation to treat was and what we mean by invitation to treat. So just put up what you think we should cover. What you think we should cover, just put it up there in the comment. Put it up in the comment, then we know that this is what we are going to discuss. It becomes easier. So just come over and we begin to discuss this concept. So we have told you that you should be starting in 2 minutes. So you have understood what we have said. Just put up a topic you feel is but I know, in my mind, I know consideration disturbs a lot. But you give me what you think is hard. I also capacity to contract. It kind of disturbs, but it's okay. We are going to discuss. But at exactly in about seconds, for 20 seconds, we should be able to start with. We should be able to start with invitation to treat, like Holly said. Just put up what you want us to discuss. Yeah, much as I know, and I know that consideration disturbs, we are going to break it down here. I know that capacity to contract also disturbs a bit, and we should be starting now. Invitation to treat. We'll begin with what this colleague of ours, Holly, requested us to discuss, is the invitation to treat. Now, I am going to use examples. Now, invitation to treat. This is the willingness to initiate negotiation. That invitation to treat is the willingness to initiate negotiation. So when somebody talks about invitation to treat, literally, that is what we mean. That you initiate negotiation. Now, some of the issues under invitation to treat are that what you must know under invitation to treat, where is the contract signed? That is one. Two, where is the offer made? If we are discussing invitation to treat, where is the offer made under activities that are invitation to treat is what a student should be able to note and appreciate. Let's take that case of pharmaceutical of Great Britain Society versus Boots Chemist. Now, in that case, there was a law in England that certain chemicals were not supposed to be sold unless they were under a guidance, unless there was a supervision of a qualified medical personnel. Okay? Now, these Boots chemists, they were selling chemicals, but there are those chemicals which people were not supposed to buy them unless there was a supervision of a qualified medical personnel. Now, somebody entered into this into this chemical shop. When he entered, those chemicals which are not allowed, they were displayed in the counter. So this person went and picked the chemicals without the supervision of the qualified medical personnel. But the medical qualified personnel had been put at the counter. So when these people picked, they came. So they sued this Boots Chemistry, saying that they allowed the selling of that chemical without the supervision of a qualified. Now, for them they were assuming that the Great British Society, for them they were assuming that the plaintiffs, they were assuming that the contract was signed, the offer was made at the counter when they went and picked. Now, the defendants, the Boots Chemists, argued that under invitation to treat, what they were under was invitation to treat. They were calling them to negotiate by placing the goods in the counter. And the rule is a contract, so an offer under invitation to treat is not made at the shelves. The offer is made at the counter by the person who responds to the invitation to treat. What does it mean if I say that an offer is made by the person who responds to the invitation to treat? Let me give you an example, local example, to explain invitation to treat. Number one, if many of you have gone to a supermarket, if you go to a supermarket and then you go and pick, I don't know whether they will copyright me. Let me use, I was going to use my drink here. Let me try to cover it. If you go to the supermarket and you go to a fridge, you pick this soda, you go and pick it, you bring it to the counter. Now, the idea of soda being in a fridge, in a supermarket, that is an invitation to treat. They are calling you to come and negotiate with them. So if you have noticed, sometimes you go to a supermarket, you pick something which is labeled 4,000. Okay? Labeled 4,000. But reaching the counter, they tell you it is 5,000. Now you enter the supermarket, you have responded to the invitation to treat, and therefore the other person who made the invitation makes the offer. So the person at the counter is the one who makes the offer. You, when you come, you ask, how much is this? And then they tell you, this is 7,000. They give you the offer. And then you either decide to buy or not to buy. So, under invitation to treat, you respond. You respond to the person who made the invitation makes the offer. So it is not you who has entered the shop who makes an offer. Okay? It's not you who makes an offer. It is that particular person who made the invitation, the owner of the supermarket, that makes the offer to you. You cannot make the offer. So that is what we call. So in this case, the medical personnel was at the counter supervising, meaning that when you bring the chemical which is not allowed to be sold, he will tell you, this one, take it back. Because at the counter is where the offer is made. The offer is never made at the shelves. At the shelves, they are calling you to come and you initiate negotiations. So the offer under invitation to treat is made at the counter. Look at that case of Harris versus Nickerson, the auctioning case. Nickerson put up an advertising for an auction, and he put up so many goods for that. He put up so many goods, and Harris said, I will go on this date, I buy. So when Harris reached the auctioning, Harris found that the goods which he had wanted had been sold, finished. They were not there. So he sued for wasting of time, and also that they had promised that these goods would be here, but now the goods are not there. So court held that the advert of Mr. Nickerson was an invitation to treat. It was not a contract in itself. There was no offer made. It was an invitation to treat. They were calling you to come and negotiate. So you can't say, you put up an invitation, I have come, goods are done, I'm suing you. No, it is just an invitation. You can only sue where there is a contract. That is why now, if we distinguish between offer and invitation, you see that in the case of career, the offer was made out. Whoever buys and uses in the prescribed time or manner will not get influenza. If they get, we shall give you a price. The offer now was already made. That an offer should be clear. An offer was clear. But under invitation, we are only inviting you to initiate negotiation. So that is what we mean by invitation to treat. Our colleagues, I'm asking you, put up the topics where you feel you have a problem in the comment, and then I will surely discuss them following what you want. Exclusive clauses, exclusion. Those should be exclusion clauses. Octavia, you're most welcome. You were here last week. Exclusion clauses in contract with some Ugandan cases. No, the cases which run them, the cases which run exclusion clauses, Octavia, most of them are English cases because they are locus classicus. They are those leading cases which were decided. Most of them, especially the Lestrange versus Glogba case. It may be hard with the Ugandan cases. I'm going to discuss them, but they will be hard with the Ugandan cases. It will be hard with the cases of here, but we're going to discuss exclusion clauses. Yeah, just put up, like Octavia has done, just put up those things that you intend us to discuss today. Now, let's now cross. I will really follow what people write here. They're now asking for exclusion clauses. I'll follow this. Let's now go to exclusion clauses. Now, under a contract, under an operation of a contract, in what we want to discuss as exclusion clauses, that exclusion means that people tend to want to run away from liability. People tend to want to run away from liability. So they make contracts. They make contracts when they are excluding liabilities from them. That if this, you're welcome, Dan, I'm sorry. Now, people want to, how do they call it? To run away from liability. For example, Doctrine, privity. For example, have you people noticed when you go to park your car, you find writings, park at your own risk? If you want to board a bus to go somewhere, you find on the ticket they have told you luggage about your own risk. There are some things they put, those small print. People are running away from liability. That is what we mean by exclusion clauses. People tend to want to run away from liability. However, there are exceptions to these exclusion clauses. There are those exceptions, and these exceptions, they are just three. Number one, signature. Number two, notice. Number three, usual dealing. There are three. Notice, signature, usual dealing. What do we mean by these exceptions? That you cannot run from liability if you do these things, if you append your signature. Now, let's discuss the signature. What do we mean by signature? Now, under signature, we mean that the moment you append your signature on a document, okay, you are bound by that signature. That signature bounds you, whether you have read or you have not read what they have given you. But the moment you append your signature, you are bound by what you have signed. Okay? So I'm going to give you two cases to explain this. We are discussing exclusion clauses. I'm going to give you two cases. Number one, we are saying that under signature, as an exception to the exclusion clauses, that the moment you append your signature on any document, whether you have read or you have not read, you are liable for whatever happens because your signature is there. Look at the Lestrange case, Lestrange versus Bravo. This is the locus crassus. You cannot discuss signature under exclusion clauses minus talking about the case of Lestrange versus Gragbo. This is a very serious case. Now, this man went to buy a machine, okay? Now, he told them the machine he wanted, and therefore he was given a machine, and they asked him to sign on the contract, the terms and conditions. So he signed minus reading. So when he reached home, the machine, I think auto vending machine, it was not performing the duty he expected it to perform. Listen, he bought a machine, but he was given to sign the terms and conditions. He he signed them. On reaching the machine home, it was not actually doing what he had wanted. So he wanted to sue. That's why we call it the Lestrange theory. So he wanted to sue. Court told him, you are bound by the document, the four corners of that document. The moment you append your signature, it doesn't matter whether you have read or not read, you are bound by that. So you cannot run away from liability. There was any other representation. Let's take another case. A case of Curtis versus Chemical Cleaning Company. Curtis is C-U-R-T-I-S. Chemical Cleaning Company. Now, this lady took her dress to be cleaned at the Chemical Cleaning Company, Chemical Dyeing Company. Now, when he went there, he told them, let's say, I can't remember, but something that don't remove my, how do they call this? How do they call my pencil in English? It has skipped my button, sorry, button. Now, make sure my dress is washed clean and then my button clean and everything. That is what they agreed. So they told him at the cleaning company, we are going to do that. Okay? Now, they made that sign. Thank you, Dory. They made that sign. Okay? Now, when she signed, when she went to pick the clothes, instead they had stained the clothes. Now, she took them to court. They were arguing that what she had wanted was come again, let me see, Curtis, yes. Now, she went to court. Now, in court, the issue was that this person had signed, okay, for the stains not to be, our clothes not to have stains and also have scribbles, quills, something like that, our buttons to be clear. Now, but on coming back, one of them had been destroyed. So she went to court. Now, court ruled in her favor, telling them that this lady was clear on what she wanted. Since she signed for this, now that you have removed what she signed for, you cannot claim that her dress has come back in good shape. So, liability was put on the bigger company. That is Curtis versus Chemical and Dyeing Company. Chemical and Dyeing Company. So under signature, you are supposed to be careful in your transactions. Even today, in your day-to-day transactions, when you are transacting, never sign minus reading what you have signed. Let's take a case of Ole. Sorry. Let's go to notice. That if you want to run away from liability, you must put up a notice. Let me explain notice using a case. There is a case of Ole versus Marlborough Court Hotel. Marlborough Court Hotel. Now, in this case, Ole and the husband, they went to Marlborough Court Hotel. They had gone for a vacation to stay there for some time. Now they reached the reception. They asked the lady, tell us where are the rooms, how much. The lady gave them a room. They went to the room. So they carried all their belongings, their property to the room. They put them in the room. Now in the room, there was a notice saying that keep your luggage here at your own risk. Luggage is kept at your own risk. That was inside the hotel. Now they put the luggage there, they moved out to go and have fun. On coming back, their luggage had disappeared. Their luggage had actually disappeared. Now they went to court. The Marlborough Hotel was arguing that in the room there was a notice that they are keeping their property at their own risk. Court said that Marlborough Court Hotel was liable for the loss of the property. Why? Much as the notice was in the room, God said that the notice, the intention of the notice, it must be clear and it must be brought to the attention of the person who has come. That a notice must be put now. In their case, a notice was supposed to be on the reception. But hiding a notice, you can't run away from liability. A notice is supposed to be brought to the attention of the person who has come to consume your property or your service. So if you hide that, park your car at owner's risk. If you hide it and I don't see it, you will be held liable. So a notice must be brought to the attention. So in the case of Ole versus Marlborough Court Hotel, court told the hotel that you have a problem. Your notice was supposed to be at the reception. You should have brought it to the attention of your customer at the reception. In the event you didn't do that, you are liable for the loss. So what do we pick here? What are you supposed to discuss when you are discussing? You are supposed to bring out the idea that a notice must be brought to the attention of the customer. Where it is not brought to their attention, even when it is there, hidden somewhere in the hotel, then the hotel is going to be liable. Okay? So that is what we mean by signature. Then the other one is what we call usual dealing. Where there is a usual dealing, someone can escape liability, or sometimes you may not escape liability. What do we mean here? Let's take a case of Huria versus Brabo Motors. Huria is O-L-L-I-E-R versus Brabo Motors. Now, this person and Huria, where Huria was buying cars from Brabo Motors, but on buying those cars from Brabo Motors, but they would take 2-3 years minus dealing together. They would deal in this year, they come and deal again in 3 years. So they had an issue, and Brabo was saying, we are usual dealers. Court said no. You can't say you have usual dealings when you deal with somebody for today and then you come back after 2 years. Usual dealing is instant. If you have usual dealing, you can escape liability. You can say, but I come here every day. You should have known this. Yeah? Normally, I don't do this. It's like going to a restaurant. You go there every day, you eat rice and meat, rice and chicken. You have never eaten rice and beans. On this day, they give you beans. But because you have been eating there every day for a period of 1 year, that is usual dealing. When you have a usual dealing, you can escape liability. But where there is no usual dealing, you can't escape. Now, in their case, there was dealing in cars, but they would sell a car today, and then they come again and deal after 2-3 years, which that was defined as not being usual dealing. So that is what we call exclusion clauses. But never discuss exclusion clauses minus discussing the contra proferentem rule. The contra proferentem rule. What we mean by the contra, after discussing the theory, you also bring out the idea of the contra proferentem rule. What do we mean by contra proferentem rule? Now, let me use UCU. If I drive a car and I park at UCU, I go to one of the offices. Okay? Now, like somebody was telling me to come and discuss for ECU students. Now, if I came to ECU and I park, I come for a discussion in whichever class you guys have. Now, when I reach there, on coming out after 3 hours, I find that my car has been stolen. Okay? I find that my car has been stolen. I'm explaining to you what I mean by the Contra proferentem rule. I come and I find that my car has been stolen. So I go to court. Remember, I entered UCU using that side of the basketball courts, that gate. Then I go to court, I report UCU, but there are posters there. Now, I park at the basketball court, but there are notices that park at your own risk. They are, let's say, at this other gate, the first gate where there is a field. Me, I don't see the notice, I park. So, UCU wants to escape liability by saying that we have a notice there. Me, I'll tell them I didn't see a notice. Now, court will apply the Contra proferentem rule. Where court cannot establish who is in wrong, court will apply the Contra proferentem rule. What does this rule mean? This rule means that the exclusion clause is going to be used against the bigger company that intended to rely on it. For example, if I go to the bank, I am the small company. The bank will give me their things with small print. If we fail to agree, court will use the clauses that you intended in the bigger company to rely on against you. So in this case, they will use that clause against UCU and they'll ask them to pay my car. Look at that case of Andrew Brothers. I can't remember the citation. Look up for that case of Andrew Brothers. So that is what we mean by Contra proferentem rule. That the exclusion clause will be used against that company, bigger company, that were intended to rely on that exclusion clause. Okay? Yes. So for more cases, they are on this channel. I have done those clauses on this channel. So let's go to another one. The doctrine of privity. Doctrine of privity. Let's now discuss the doctrine of privity. But just to remind you, every Sunday at 2 we shall be here, and also every day starting Monday at 10 p.m. on the other channel, Voices of the Bar, for 30 minutes. Don't sleep minus appreciating a concept. I'll be coming with the concept, brief concept, every day, 30 minutes. If you're not on live at 9, 10 to 10:30, if you're not on live at night, kindly in the morning, check it out on that channel, Voices of the Bar, every day. Learn a new concept. I'm going to make sure I simplify. I come with one concept, I spend all the 30 minutes discussing it. Where there are cases, I'll put them there, I bring them out clearly, and you can just watch that to go and answer a paper. So, you can send other topics you want me to discuss. I'm just going to discuss now, right now, the doctrine of privity. The doctrine of privity. Privity. Now, let me hope you all have your Contracts Act. Let me hope consideration. I know. Ali Maguru, welcome back. You were here last week. Yeah, we are going to discuss it. I agree with you. This one is disturbing people. It becomes a problem. But of course, by discussing doctrinal privity, we have cited of consideration. I'm excited about the 10 p.m. idea, yes. Okay, now, let me use my friend here, Dorin Musoki. When I make a contract, me and Dorin, and then let's see Maguru. If a contract, Maguru, is between me and Dorin, Maguru, you cannot enter into this contract. You cannot enter into this contract because it is between me and Dorin. So that is what they call privity. That a party who is not part of the contract cannot say anything about it. Unless you have been mentioned. Privity means that if a contract is between Dorin and Walter, wholly, you cannot totally, sir, you can't discuss a thing under that because it is not between you, it is between the other two people. Unless you apply section 64 of the Contracts Act. Let us all open section 64 of the Contracts Act. Hope it is the one. 64 years. Rights of third party to enforce a contract. When can you enforce? Let me read for you. Let us go slow about these colleagues. Subject to this act, a person who is not a party to a contract may, in his or her own right, enforce a term of a contract. Here they are saying that a person who is not party to a contract may, in his or her own right, enforce a term of a contract where, now, they are telling you that if you are not part of the contract between Dorin and Walter Holly, you can enforce it where they have given you scenarios where you can come and enforce it. But at common law, a contract made between Dorin and Walter, if you are not part of that contract, you cannot enforce. You cannot even come near it. Now, when you read section 64, they have given you areas where you can come and enforce. Of course, this is the first exception, but I'm not yet there at the exception. I'm still giving you the introduction. Now, where the contract expressly provided that he or she may do so. Now, if Dorin and I include a clause and say, where we are not, Maguru and Wole can come and enforce, then Wole and Maguru, you have gotten a right to enforce a contract. All this should show you that a contract, when you are not party to the contract, you cannot enforce it. Unless the people who have made that contract, Walter and Dorin in this case, unless we come and say, where we are not, we call you to come and enforce. You understand? Of course, I can't get your feedback. 2, a term of a contract confers a benefit on that person. If in one of the terms you are a beneficiary, then you can come and enforce. So, all in all, what we are saying, privity means that when you are not part of a contract, you cannot enforce shut up. You can't say a word. Because you are not part of a contract. And that was the general rule at common law. Let's read this one. Subsection 1b. 2 says, does not apply where on a proper construction of the contract it appears that the parties did not intend the term to be enforced by a third party. That if in my making a contract with Doctrine, we, on proper construction, we say that we don't intend anyone, even if they have a benefit in this contract, to enforce it, then you can't enforce it. So basically, that is what we mean by privity. There is a case, I want to urge you to go and read it, Selfridge versus Dunlop. Yes. Now, when you give a definition of privity, you now bring that case of Selfridge versus Dunlop. Now, there are exceptions, okay? There are exceptions, and this is what they normally want to ask. There are exceptions to the doctrine of privity. That we are saying that if you are not part of the contract, you cannot sue on it. Now there are exceptions where, even when I am not part of the contract, where I can come up and sue. Let's have a pen and paper. You begin to note some of these points. I'm going to give you a few. Number 1, position of the act. Colleagues, if you are discussing the doctrine of privity and you are discussing the exceptions, the first exception is position of the act. Don't forget it. Position of the act. The moment you mention it, you bring section 64. What do we mean by position of the act? That in the act, I have the old contract acts. Now, in the act, we need to update these things. So, in the act, this contract act, okay, it has given you ways how someone who is not party to a contract can enforce it. The ones I've read. If the contract confers a benefit on you, if the parties agree that you enforce it, that's when you can enforce a contract. So meaning that the exceptions you are discussing things where a third party can come and enforce a contract where they were not party. So point number 1 is the position of the act. And in there, you quote section 64 and you describe where section 64 allows someone who is not part of the contract to come and enforce that contract. Point number 2. Bills of exchange. Hope I remember them. Bills of exchange. Now, bills of exchange these ones are like checks. I'll give you an example. If me and the Holly we go to the bank. No. If me, I go to the bank and I open up an account in the bank, they give me a check, maybe 50 leaflets or 25 or 100. So my check, the contract of me having an account in the bank is between me and the bank. Okay? So I open up a contract, me and the bank, I have an account in their bank, and then I have a checkbook. So I go, I issue Holly a check. Maybe she supplied me or he supplied me. Holly, are you a she or a he? Just to be sure. So, Holly supplied me a few things. I now issue her with a check. Now she goes, she banks a check. She banks, he banks a check. Now, when Holly banks that check, it bounces. Okay? When the check bounces, Holly can sue. Remember, she was not there in our dealing with the bank. But me now, I've given her a check. That check has bounced. She can sue me or the bank, depending on where she wants to sue. Okay? But issue is, a third party is now enforcing a contract where they were not party because of bills of exchange. I hope I'm clear on that, colleagues. Okay? And the other one is what? Agency. The other point is agency. Agency. Now, I know you're going to cover agents. If you read section 117, it defines agency, principal, under the Contracts Act, section 117. Yeah. Yes, agent, principal, sub-agent. Now, under agents, there is a principal who is the boss, and then there is an agent who is working on behalf of the principal. Now, the contract is signed between a principal and an agent. So an agent is working on behalf of the principal. Okay? But an agent may be working and they do a mistake to someone or a sub-agent. Now, a sub-agent or any other person will sue on a contract which was made between an agent and a principal. Here we are looking at third parties. How can third parties come in? For example, if a principal, who is now in this case Holly, agrees with the Doreen to be the agent of the principal Holly. Now, maybe the work they are going to do is to construct loads. They come, and now the agent Doreen demolishes my house. So I can sue on their contract. I can even sue the principal. But I was not there when they are making their contract. Me, I have been affected with their contract this side down. Now I go, I sue on them. I sue the two people. Okay. So that is how agents comes into play. There is a principal-agent relationship where someone who was not part of the contract can ably sue about that contract. Then the other point is third-party insurance. Third-party insurance. Third-party insurance. Third party insurance, what do we mean? Third party insurance, most of you drive cars. The issue is like this. You have your car, you go to Swico, those insurance companies, you have a third party on your car to carry maybe ABCD people. Now that third party you have on your car, okay? The contract was made between you and the insurance company. But now you give me your car. I get issues in your car. I can sue you guys. But I was not there when you were making up your programs. Okay? So third insurance comes into play. Okay? So those are the third party risks. That is somebody who was not there. Me who have just given your car, I get issues, accident, what, or they knock me, I can sue. But in that contract, I didn't sign anywhere. I'm trying to break this for you. Look at negligence. Negligence as the other exception. Now, negligence, I don't know how to explain this. There is that case of Donahue versus Stevenson. You're going to discuss negligence in second year under tort law. But we want to use it. Okay. Now, in the case of Donahue versus Stevenson, now in this case, my God, let me try to explain this case for you. Now, in the case of Donahue versus Stevenson, Stevenson was the manufacturer of the ginger beer, but he was a manufacturer. He was the one who was making them. So, a friend of Mrs. Donahue, is it Manila? A friend of Mrs. Donahue went to the shop, to the retailer, who is not Stevenson, to buy a ginger beer. When she bought a ginger beer, Donahue took it. It was opaque. You can't see what it is inside. Now, on taking it, he realized there was a floating snail. So she got complications. And now, she sued. She sued. Remember? And for her, she sued a manufacturer. Remember, the beer was bought by a friend from a retailer. But again, Donahue, the third person, is suing the manufacturer. So, Donahue was the third party who was suing for the damages. And the court agreed with her. Court said that, Lord Atkin, that where there is, that all manufacturers should have a duty of care. That when you don't respect your neighbor, your actions causes harm to your neighbor, you will be liable. So this issue of third party comes in that Mrs. Donahue was not even the person who bought, but she came and sued and succeeded under the principle of neighborhood principle, that you as the manufacturer, you should have a duty of care to your neighbors. You must produce things which are up to standard. That's how negligence comes in. But I ask you to watch a video of Donahue versus Stevenson for you first appreciate the flow of the case. It's a very big case that you're going to cover in second year. the whole of second year, taught 2, you'll be discussing negligence, and that is one of the leading cases you're going to discuss. So go and look up for this video of Donoghue versus Stevenson. Then the other one is trusts. Another point is trusts. Another point is trusts. Now, when making a trust, I'll just give you an example. If I buy land, I say this land is for the benefit of my children who are now 5 years, 7 years. When they get 18, this land should go to them. Now I trust the documents of the land with Doreen, that when my children get 18 years, please hand over the land. I trust Doreen with my titles for the land that belongs to my children. When my children gets 18, no. When I buy my land, I buy it from Doreen. I tell her, Doreen, this land is for the benefit of my children. When they get 18, you send all these transfers to them to make a transfer. But then I tell Holly, that look here, Holly, when my children are 18, please go and demand for this. Now, if Doreen doesn't want to give my children, Holly will come and demand, or even the children, because they have a benefit in it, they will come and demand for their property. Okay? So that is the sequence of trust. There's a trustee who is supposed to demand the property of the other people. So, yeah, and very many others, assignment, and very many others. Let's have other topics. Let's have other topics. You can type in other topics, and then we begin to discuss them. Let's have those topics coming. We are going to miss you first years. We are going to miss you in August, because all the other first years in the country are coming in August. So these lives we shall be discussing first semester things. Maybe we shall create for you. Estoppel. Agaba Joel. Misrepresentation is it must be the second semester. Promissory estoppel. Consideration, I'm going to discuss it. That one is a must. Promissory estoppel. Let me start with promissory estoppel. If I go to my boss, let's take an example. Let's take an example. If I go to my boss, Doreen, I tell her, Doreen, my name is Walter, I want to study law, but my problem is tuition. Then she tells me, no, it's okay. You go, apply, I'll give you tuition. I'll give you tuition. First semester, I'll give you all the tuition. So, I go to UCU, I pick admissions, I go to Uguju, I get I get a hostel, okay? After getting a hostel, I go to somebody who cooks well food there. I pay food for the whole semester. Now I'm waiting to start. Then I go to Doreen. I tell her, Doreen, school has started tuition. Then she tells me, no, I'm not giving you. That's where you can sue her under promissory estoppel. Promissory estoppel means that you are estopped from not fulfilling what you promised. For as long as I can prove that I relied on your promise, that is it. That is it. No more, no less. You, the person who is claiming you were lied to, you must prove that you relied on their promise. The moment you prove that I relied on their promise to go and get admission, to go and clear a hostel in Bugutu, to go and clear my food, and now he's saying that he cannot pay, okay, then is stopped from not fulfilling. Court will say, no, fulfill. Okay. So, we are saying that you are stopped from not fulfilling. Now you, the elements are that you, the person claiming, you must prove to court that I relied on their promise. Okay? That you relied on that promise. Short of that, then you cannot claim anything. Okay? So that is what we mean by promissory estoppel. You are estopped from not fulfilling. The moment people are able to show that they relied on your promise. Okay? So that is what we call promissory estoppel. No more, no less. Somebody asked if there is a case. I think the case of London property can work there. London Central Properties versus High Tree. I think it can work there. Versus High Trees. It can work there. London Central Property versus High Tree. It can work there. Any other question before? I want to discuss those small things before I cross to consideration. Any other topic that you feel we should discuss? Agaba, you may just have to go and watch this video, this presentation, because I understand this topic normally is covered in second semester. So I think you must be in second semester. If not, you are in first year, but they have told you to discuss this topic. It is normal for second semester, reshaping factors. We discuss them in second semester. But the video is up there. Well discussed. Kindly go and watch it out. Capacity to contract, very good. Agawambi, we are sorry, but kindly look it up at this channel. The video is up. So capacity to contract. Consideration is going to be my last. So I'm going to discuss capacity in a few minutes. Then I will cross to consideration if there is any other topic which is disturbing. Now, capacity to contract. Don't really want to away. Those you promised to give them their wedding contribution, please don't run away. Or you want to sue those who didn't give you, but you had relied on them. Eh? You look at section 58, 57, 58 about somebody. Okay, maybe it will take a little time. Section 56, 57. Is it the one? Non-gratuitous act. Obligation person. Yeah, it's something about gratuity, gifts. Some things are gratuity. You have impressed me during what about pledges? You want to arrest people. If that one is, then we shall all be arrested because we have promised many people and we forget not to give. So let's go to capacity contract. Members, I am going to highlight for you under capacity contract what you should know there. No more, no less. I want to go into details. I'm just going to give you a general overview. The contract, the topic capacity contract, is mainly about how are they called? In that topic, how are they called? I'm forgetting my God. Minors. Now, under that topic, you know these three things. 4. Get somewhere to write. Get somewhere to write. Contracts made by minors. That is 1. 2. Contracts for necessaries. Then beneficial contracts. Then contracts of persons of unsound mind and drunkards. Unsound mind and drunkards. Unsound mind and drunkards. And then capacity. Capacity of corporations. Capacity of corporations. But contract law, try to understand it as a person and appreciate it. So let's do those ones. Number 1. Do minors contract? That's the first thing which must be running in your head. Do minors contract? Okay. Do minors contract? The issue is, yes, minors contracts. Now, if minors contract, when do minors contract? And they are liable. Sorry, the issue is minors don't contract, but there are exceptions where minors contract. And when they contract, they are liable. Let me repeat it. Do minors contract? No. They don't contract. Number two. So, when do minors contract? Now, when do minors contract? And when they contract, they are liable. And when they contract, they are not liable. When do they contract when they are liable? And when do they contract when they are not liable? I have summarized the topic of capacity contract by those words. I'm going to explain them. When you contract with a minor, for example, for supplies of necessaries, for necessaries. Now, when a minor is under a contract of necessaries, okay, it is the duty of the person who is going to supply a minor. It is your duty to find out whether, okay, whether the goods you are going to give a minor are important, are needed in the life of a minor at that particular time. That's the first thing you should know. That if you minors are contracting for contracts of necessaries, the first thing is, you the person supplying the minor, you must find out that the goods I'm giving the minor, does the minor need them? Are they needed in the life of a minor at that particular moment? Are they of any importance? It is your duty, even when the minor comes to you and says, give me this, that is okay. But you must find out that what I'm giving the minor, is it needed by the minor? Okay, that is one. Two, where the minor fails to pay, they cannot be charged of anything. It is now your duty, in what we call the doctrine of restitution, to come and you pick all the goods you have given to the minor in excess and you take them back. That is how a minor has been protected. Now, when does a minor contract and the minor is liable? For contracts of service, apprenticeship. When a minor contracts to get knowledge, a minor is liable. If the contract you have entered in with a minor, it is the minor benefiting, then a minor will be held liable if they misbehave. Look at that case of Robert versus Gray. They were teaching a minor how to play tennis. You're going to get money, you're going to benefit ABCD. Now, in such a contract, if a minor misbehaves, then a minor is going to be held liable the way he was held liable. Listen, colleagues, where a minor contracts and the contract is that one of service, apprenticeship, beneficial contract, then a minor will be held liable. Why? Because the minor has been getting service, has been getting knowledge. If you contract with a minor to give them knowledge, to give them a service, to benefit their life, then they cannot misbehave. In that, they will be held liable. However, if a minor contracts under a contract of service or benefit or apprenticeship, but the conditions are not favorable for the minor, a minor will not be held liable, even if that contract is a beneficial contract. Even if it is a beneficial contract. I'll give an example. There's that case of first trade versus methods. You check it out in Ben's book. Now, a minor was, shifting. So, a minor went and got a car to shift from here, let's say, where we are, Sebuku, let's say to Bodamwaya. Now, a minor paid them. Of course, they were helping a minor. A minor was benefiting from that contract. They are transporting his property to another place. But they told the minor, whichever problem we get on the car, it is you to pay. Fuel got down, minor pays. The car breaks down, a minor pays. So, court held that where the conditions are harsh to the minor, a minor will not be held liable, even when that contract is a beneficial contract. Hope I'm clear. That even when a contract is beneficial, but the conditions are harsh for the minor, then a minor will not be held liable. Let's take an example. There's that case I'm forgetting, where they were teaching a minor to play, I think, tennis. No, there's a game. But she was not allowed to marry. She was not allowed to move anywhere. Yes, much as the contract was benefiting a minor, but the conditioning surrounding the contract were harsh, a minor will never be held liable. Contracts of unsound mind and the drunkards. Colleagues, somebody of unsound mind or a drunkard, they cannot contract, no more, no less. But where they are in lucidity intervals, that some people, they are okay between January and February and June. From June to October, they are not okay. So when they are okay, they can make a contract. But we know them, they are of sound mind, unsound mind. But where they feel they are okay, they can make a contract. Where they are not, they cannot make a contract. So you must bring out that distinction. It should be section 11, clause 3. Let's go to section 11. I'm not sure, guys. I'm just remembering a bit. So section 11. A person who is usually, section 11, clause 3. A person who is usually of sound mind, but occasionally of unsound mind, may not enter into a contract during periods when he or she is of unsound mind. It's what we call lucid intervals. That occasionally, sometimes it's okay, sometimes, so when it's okay, he can contract. When it's not okay, he cannot contract. And then you put cases. Then let's go to capacity for corporations. Capacity for corporations. That case was to dance. I know. Thank you. Now, let's go to corporations. Now, here, under corporations, as you'll be reading it, this is what they want. no more, no less. They are telling you under capacity contract that a company, those days, there were objectives of a company. That if during you have a company to supply rice, that is your company, to supply rice, okay? You cannot contract in something else. That it was straight. That if your objective was to supply rice and we find you supplying posho, you have no business. You don't have capacity to contract under posho. Your objectives are saying you must be supplying rice. Stick to that. But with the time, things have now changed. There is that case of Hashbale versus Rich. Read it under capacity of corporation. Hashbale versus Rich. Now, what they want you to say in capacity of corporations, they want you to say that in the old days, when you had an objective, you would stick to objectives. You don't contract for things which you were not given under the memats. But now, things have evolved. One person can be supplying maize, posho, beans, the same company. You have many objectives. That is all they want you to explain. So I ask you to read Benny's book, particularly capacity of corporation, but that case of Hashbari Railways versus Richie is locus cascus in capacity of corporations. So there are cases under capacity contract, De Francisco versus Bannerman, Robert Gure, first method. Which other case? There's that case of there is that case of Robert Gray, Ryder versus Wombwell, Ryder, Wombwell, Robert versus Gray, First versus Method, De Francisco versus Bannerman, Dolly versus White Stadium, that case is Ashby Railway Carriage versus Richie. Yeah, and very many other cases in there. So, any other topic before I cross to consideration? As you also relax a bit. 2 hours are too long. Okay, any other question? Just put the topic, we discuss it briefly. Then 30 minutes to 4, we begin on our consideration, and that will be our ending. Any question, colleagues? Any question, colleagues? Okay. Mike, I'm seeing such for one more gala consideration to Gitanic. Number 1, under consideration. Note for me these things. What is consideration? Number 2, types of consideration. And number 3, rules of consideration. Now, those are the ones we discuss. But now, under rules of consideration, we have the exceptions of privity, which we discussed already. Then we have the exceptions to Pinot's case, that is under part payment of a debt. When we are discussing the rule part payment of a debt, then we have exceptions to Pinot's case under rule of part payment of a debt. Then we have exceptions to Pinot's case, and that will be all with consideration. So I think now what is disturbing, particularly, should be the rules of consideration. Should be the rules. Now, consideration is defined under Section 1 of the Contracts Act. Let's get. Consideration means right, interest, profit, or benefit. Listen, colleagues. These words almost mean the same things. That consideration means right, interest, profit, benefit. Accruing to one whose party or forbearance, detriment, loss, responsibility given or suffered or undertaken by another party. They are telling you one side there is the benefit and the loss, detriment, interest. Okay? What does it mean? Consideration means that I lose, you lose. I benefit, you benefit. That on both parties there is the benefit and the loss. Okay? On my side, there is benefit and loss. On your side, there should be benefit and loss. The moment there is benefit and loss, then there is consideration. Our example is here. I bought this soda from a supermarket. I gave them 1,000. Okay? Meaning that I lost 1,000, I gave it to them. And they gave me a soda. So I benefited by getting a soda. But I lost 1,000, but I got a soda. What happened to them? They lost a soda, but they got a 1,000. So the benefit and loss is on one person. It should be on both people. Where one person has benefited and maybe caused the loss, and you have only benefited, there is no consideration. I don't know if I'm clear, colleagues. I repeat that for our understanding. They should be loss and benefit on both sides. Only if you are selling me your land, your 1 acre of land in the village where you come from. Only where do you come from? We know the price of land there. Where do you come from, Holly? Mr. Holly, write your area. Where you come from, not where you are now. Rubindi. Rubindi. Is that what you say, right? Oh, Mbar. Hey, how much is an acre in Mbar of land? An acre of Mbar of land in Mbar, like how much Rubindi? Ruby, like how much? Give us a figure, an acre. 60 millions, mama. Yeah. Embarara. 60 million. Anyway, no. Kali. Oli. If you have your acre of land in Imbarara and I'm giving you 60 millions, okay? I want to buy it. So, I give you money, you give me land. In other words, I have lost money, I have gotten land. You have money, it's interest, right, benefit accruing. So that is what we mean by consideration. When we say, was there consideration? I'll give you an example. Like, I remember when they were teaching us this topic, we started to joke about it. I'm not doing you now laughing. We started to joke about it that if you, during a girl, you want me to discuss for you, what is the consideration? You're going to come, I discuss for you, and then I'll be clear. I don't want money. What is the consideration? Our joke would be that I discuss for you, we have a romantic affair. You understand? So people will be saying, what is the consideration? Issue is, what have you lost? What have you gained? So, Holy, I have bought your land, you have lost land, but you have gained money. I have lost money, but I have gained land. It must be coming from both sides. The loss and benefit is on both sides. Where it is on one side, there is no consideration. Where it is on one side, there will be no consideration. Now, consideration takes many forms. Consideration is not only money. You don't have consideration can be man. No. Consideration can be service. Can be counted on service given. It can be a property. It can be a good. Meaning that consideration can take many forms, can take many directions. Don't be rigid and say that consideration is the money. No, it can be service. Now, there is a case of Chudi versus Misa. We don't go into facts of that case, but you cannot define the consideration minus saying Chudi versus Misa, because that definition you have in the Contract Act is the holding of Chudi versus Misa. So we say consideration under in Chudi versus Misa was defined as you put this definition which you have here. That this definition was the holding in Chudi versus Misa. Because in that case, they were defining what is consideration, what amounts to consideration. So you can't write the definition and you don't include that word Chudi versus Misa. That consideration under Chudi versus Misa was defined. Chudi is C-U-R-I-E, Misa is M-I-S-A. Okay? Chudi versus Misa. You don't fail to do that. So, now, there are types of consideration. But the mind you should have when discussing consideration, the mind you should have should be in any question they ask you, was there consideration? This should be your question running through as you discuss this number. Was there consideration? And when you ask, was there a consideration, what comes to your mind is that, was there a loss and benefit on both sides? I don't know if you understand. Was there a loss and benefit on both sides? Okay. So you look at all those scenarios, all those facts there, and then you say, this one did this, okay, this is a consideration. How about these people? Yeah, there's no consideration. Because this person gave, they never gave anything. Meaning there you're going to be able to answer that question. So now let's go to the types of consideration. We have executed type, executed, and past consideration. Executed is the one we've just discussed, where we say, Holly has sold me land in Rubindi. I've given him money. He has transferred my land to me. It is done. It is executed there and then it is present. Then executed is in the future. We agree. I give you money. You deliver for me my things in the evening or in 2 weeks' time. It is in the future. We have agreed. I've given you money, but you deliver in 2 weeks' time. So that is executory. It is in the future. Now, our emphasis will be put on past consideration. Number one, the definition is past consideration is no consideration. Past consideration is no consideration. Past consideration is not good consideration. That is the ultimate meaning. Past consideration is no consideration. Past consideration is not good consideration. I'll give an example of past consideration. Let me give an example which Professor Ben gave in his book. It makes a lot of meaning. Let me look for it here. So we discuss what Ben gave. Past consideration, I can't see it. The general